It's past 1:30 now, so we'll get started and end our comic routine here. This is Eric Hauge, Executive Director of Homeline, and with us we have Homeline's Managing Attorney Mike Braw, who will be presenting today and answering questions. Again, today is Thursday, May 21st at 1:30 p.m., and this is our fifth weekly webinar designed for landlords and property managers regarding tenant landlord law during the pandemic. Again, Homeline is a statewide tenant hotline, a nonprofit organization that provides legal advocacy and education services for renters. We've been around since 1992, and we advise tenants in English, Spanish, Somali, and Hmong. We're going to get to the Q&A in just a minute here. On a weekly basis, we are going to continue these for the foreseeable future, and we are posting all of the recordings of our webinars on our website. So every week at 1:30 on Wednesdays, we host these for tenants and advocates, and Thursdays for landlords and property managers. And for the most part, unless there's major legal developments, we're going to set aside much of the time for Q&A. So we did get a number of questions submitted in advance that we'll start with, but please feel free to submit questions via the question and answer Zoom tool or over the chat, and we'll get to them later in the presentation. With that, I'm going to hand it over to Homeline's Managing Attorney Mike Braw. Thanks.
Thanks, Eric. Hello again, everyone. Many of you are joining us again almost on a weekly basis, and we appreciate that you are finding these useful, and hopefully this one will be as well. I know we do have a lot of questions. I'm going to restate sort of the status of where we are right now. Take me 10 minutes, and then we're going to dive into questions that have been submitted in advance. I know we have quite a few questions in advance, but I am certain we're going to be able to get to a lot of submitted questions during the day today. And those questions can either be submitted through the Q&A or on the chat box, or I believe you're able to raise your hand and get called on. Eric made that available a couple of weeks ago, and we still have that ready. But quick update on the status of landlord-tenant key laws that we're dealing with when it comes to COVID-19, which is really what these webinars were designed for, is to try to inform everyone. Again, we do this once a week with tenants and advocates that work on behalf of tenants, and then again, once a week with landlords. The rules have changed so much in the last month and a half, and so frequently, sometimes without much warning, that it makes sense for people like us who, this is what we do for a living, is we know landlord-tenant law, to share what we think the new rules are, so everybody's at least on the same page going forward with what the rules that we need to follow are based on state law and perhaps city law and state and federal law. So the most important law, I think, in the COVID-19 era is still in Minnesota, the governor's moratorium on evictions. We talked about this last week because it was announced last Wednesday night. So a week ago last night, the governor extended what's known as the peacetime emergency. So the peacetime emergency is the most important time reference for us, because that is where the governor's eviction moratorium is tied. This is a little bit confusing because we hear on a weekly basis about things that are opening up. Last night, the governor talked about, I think it was outdoor camping and restaurants with outdoor seating and things like that. And so it's confusing, and every week we get questions from tenants saying, wait a second, does this mean a landlord can go file an eviction or not? I can't really understand what's happening. And the short answer is no. A landlord in Minnesota, their ability to file an eviction is unchanged from where it was last week, or really since the first eviction moratorium was declared in mid-March. So the current eviction moratorium declared by Governor Walz extends through June 12th, which is a Friday. So for a lot of practical purposes, a landlord couldn't file an eviction realistically, meaningfully, until the 15th of June because it's a weekend and it's hard to file at the courthouse on the weekends. There are exceptions to that rule. If the tenant has violated a specific statute that says that a tenant can't have illegal drugs, guns, stolen property or prostitution in their rental property, or also if they're endangering others. Those are the two notable exceptions in the state's limit on when a landlord can file an eviction right now. It's not the only limit. The other limit is actually a federal rule. It's called the CARES Act. And the CARES Act is federal legislation that does a lot of different things, but one of the things it does is it stops evictions from being filed in buildings where there is a federal subsidy involved or in play. So pretty much anything you can think of that has a federal subsidy attached to it is going to be protected under the CARES Act. And Section 8, project-based public housing, a Section 8 voucher, low income tax credit. Those are all going to be things that are protected under the CARES Act. And the difference, I should go a little bit further. If it's a smaller building, 1 to 5 units, I believe, and there is a federally backed mortgage by Fannie Mae or Freddie Mac, then the CARES Act applies there as well. And so our best guess right now is 20 to 50% of Minnesota tenancies would be covered by the CARES Act. And so, all right, that's good to know, but what does the CARES Act do? Well, it makes it so a landlord can't file an eviction until July 25th for non-payment. Just for non-payment cases. You can still file for unauthorized occupant or a lease breach or something like that. But for a non-payment of rent eviction, a landlord's not allowed to file if the CARES Act is controlling until July 25th, at which point the landlord has to give a notice for at least 30 days saying, hey, tenant, you owe money. Here's how much you owe. And if you don't pay, then I can go file the eviction against you. So if the CARES Act is in play, the landlord can't file the eviction until effectively August 25th. So there's a state law analysis, there's a federal law analysis, and that's the status of when landlords are allowed to file evictions currently. Additionally, as part of the governor's eviction moratorium, there's a ban on terminating tenancies. It's not much more elaborate than that, how that is phrased. So the question has been throughout this entire COVID-19 epidemic, the landlord-tenant question about notices. So what we're talking about when I mean a notice of non-renewal, a notice to quit, a notice to vacate. They're called a lot of different things by landlords, but we're talking about where the landlord has decided not to continue with that specific tenant. They're not renewing their ongoing contract with them, or they don't want to. Under the old rules, pre-COVID-19, if the landlord wanted to end the lease when it ends, all they'd have to do is give the proper amount of notice. So that would be in writing and properly timed. But the termination of tenancies no longer allowed under the COVID-19 era ruling. So the easy questions under that analysis are, what if we have a tenancy that is ending during the peacetime emergency? So if you have a tenancy where the landlord has told the tenant to vacate by the end of May, again, it was properly timed, it was in writing like it's supposed to be. The peacetime emergency is going to extend past that point. So a May 31 notice to vacate or non-renewal would not be enforceable by a landlord. The normal enforcement mechanism for that landlord would be on June 1 in this scenario to go file an eviction for what we call holding over. And so that isn't something a landlord can do. They can't file the eviction and they can't terminate the tenancy. So that notice to vacate effectively gets wiped out, especially if the landlord accepts rent in June. Then I think that there's no good argument that they have that notice to vacate has any validity at all. My really cautious advice, although look, I run a tenant hotline. That's what Homeline, the main program that we have is. I don't advise landlords. But if I were advising a landlord who was asking me, do I need to give another notice? My short answer would be, yeah, I'd give a notice once the peacetime emergency is declared over. And if I wanted to give a notice, that's when I'd give the notice at that point, but not any sooner, and not projecting it out, hoping that the peacetime emergency gets lifted, because if it doesn't, then you're stuck in the unenviable position as a landlord of having to tell potentially that next possible tenant that was going to move in on June 1, because you were expecting the current tenant to leave by May 31, that they can't take the place because the current tenant won't leave and there's not much you can do to make them go. So Anyhow, those are the two big issues that I think really dominate everything else when it comes to landlord-tenant law in the COVID-19 era. There's other issues that come up as well, but the state moratorium on evictions and the CARES Act both limit what a landlord traditionally has for the primary remedy, and puts it on pause until a later date. So with that being said, as promised, in about 10 minutes, I'll let Eric start with the first question that we had submitted in advance.
All right, thanks. First question is, prior to the moratorium, we provided a non-renewal and or settlement agreements for a couple tenants to vacate at the end of April. They have failed to vacate. I know we can't go to court at this time, but is it required or best practice during this time to send an additional notice to the tenants that says something like, right now we're not able to enforce, but when we can, we will? Or could that make things worse?
I guess the landlord could send some sort of conditional notice. I mean, I'm not going to go through the answer again because I just really did describe that exact scenario where a landlord had given a notice to vacate for a time during the peacetime emergency. And in our example we just heard from Eric, that was the end of April. Clearly, that is during the peacetime emergency, so a notice to vacate during that time, not valid. It has no legal real meaning. And if the landlord tried to enforce it, they'd be violating the governor's executive order. The attorney general could go after that landlord for $1,000 and up to 90 days in jail. It's a misdemeanor. And so anyhow, that notice is clearly not enforceable. Once again, if the landlord in this situation accepted rent for May, that notice is pretty much done. I guess if a landlord really wanted somebody out, they would say, you know what, I'm not going to take your May's rent. I'm not going to take your June rent. I'm going to wait until this is over, and then I'm going to try to evict based on that notice to vacate that I gave for the end of April. I'm not sure how financially sound that move is for a landlord, but I get, because we don't know when the peacetime emergency is going to be ended officially. I mean, right now, the party line from the governor's office is, you know what, it ends on June 12th, unless we say otherwise. But they've said that for 2 months now, and so we don't know when the governor's order will be lifted officially. I'll believe it when it actually is announced by the governor that it's going to be lifted, not really until then. By the way, it could happen another way. The legislature can end the peacetime emergency. However, under the state law that creates the ability to have a peacetime emergency, both chambers of the Minnesota legislature, both the Senate, which is currently Republican majority, and the House, which is currently Democrat majority, would have to vote to end the peacetime emergency. So both houses would have to do so. Now, the session is over, but if the governor decides to try to extend the peacetime emergency under the peacetime emergency rules, and that extension happens during a time when the legislature is not in session, then the governor is required to call a special session again at that point. So the House and the Senate have a chance to vote against the extension of the peacetime emergency. But anyhow, we don't know when it will end. So that notice to vacate for the end of April, my really cautious advice to a landlord would be, you know what, wait until the peacetime emergency is actually lifted, and then give a new proper notice for 1 month or 2 months after that would be the safest route that is probably unattackable legally, versus trying to give these mid peacetime emergency notices, which are maybe not going to be enforceable at all. We just don't know because courts aren't open to hear cases like that.
And the next question, what's the anticipated approach that housing courts will take to address eviction actions filed prior to the moratorium?
So I'm assuming from this question that we're not talking about the ones where it's the drugs or the guns or the prostitution or the endangering other tenants issue. We're talking about just a standard eviction, probably for non-payment of rent, which, you know, well over 90% of evictions in Minnesota are for. In those situations, if the landlord filed the eviction prior to the moratorium being ordered and they hadn't gone all the way through the eviction process and removed the tenant through the writ process, the final stage of an eviction is that the sheriff will actually come to the tenant's home twice. Once, they'll put a note on the door saying, tenant, you've got 24 hours to go. After the 24 hours, if the tenant isn't gone, the landlord calls the sheriff again and schedules what's known as a move out. And the second time the sheriff comes, they will physically remove the tenant, at which point the landlord is free to change the locks and empty the place out, really regain possession for any observer would say, okay, the landlord's clearly in charge of the place now. Before that, they were not. So anything prior to the enforcement and actual, execution of the writ of recovery was put on hold, was put on pause by the governor's order. It was specifically referenced. And then the question becomes, what happens to these cases that were filed and were somewhere in the process during the COVID-19 epidemic? My best guess is, based on what we've been hearing from the housing court and from the Supreme Court in some directives, is that they'll probably be first in line. Those cases will be first in line. Many of them, by the way, have been dismissed. I believe that probably it was the landlord unilaterally dismissing the case, thinking, well, what's the point in maintaining this? And I'm not sure when it's going to happen. But if there's still active cases that are out there, they probably go to the front of the line for evictions, is the one advantage they have, which doesn't mean that a landlord should go down and file an eviction today for non-payment of rent. I think simply, by the way, you can do that logistically. Technically, you can get into the computer system, file an eviction. But I think filing an eviction right now is a violation of the governor's order. I don't even think that's a hard question. If a landlord is thinking, I want to get to the front of the line as much as I can right now, filing an eviction today, I would not recommend, because I think it is a violation of the governor's order, which brings to the executive order fine mechanism into place. The attorney general could come after that landlord for filing an eviction during the peacetime emergency.
The next question. Landlord has forgiven over $5,000 food and public resources. Tenant has not paid, communicated, or followed up at all on resources. What should we do?
Okay, I'm not exactly sure what all that is referring to. The food, and what else was it, Eric? Food and what else?
Public resources, and maybe referrals to where you can get additional financial resources or something, I'm guessing.
Okay, yeah. And I apologize that I have Eric repeat the questions. I can't actually see them the way my computer's set up. I can see the Q&A and the chats, but I can't see the ones that have been submitted in advance, although I had looked at them before. The wording about it sometimes is a little bit tricky to follow. All right, so the first thing I'll say about rent is, number one, it's due. So the governor's order banned evictions right away going forward until the governor says otherwise. But the governor's order also said that rent is due. One of the things that we heard a lot when the governor's order came out, and what I'm talking about is mid-March through early April, there was a lot of talk about rent strikes. Rent strikes where the tenants would refuse to pay their rent, cancel rent, rent suspensions. There are all kinds of phrases tossed around. And I think that local tenants got the notion that this was something that might be viable from other tenant groups throughout the country and around the world, honestly. In Europe and New York were the places where I remember seeing it most prominently discussed. To my knowledge, it hasn't been enacted anywhere. I know it's not been enacted in Minnesota. Rent is still due. And so the tenant's debt, if they're not paying anything, is piling up. The problem for a landlord is the remedy that landlords use in Minnesota when it comes to not getting paid is not currently available. You can't file an eviction. So that hammer that landlords generally have, that's what we refer to it, the tenant attorneys, we always refer to it as the hammer, because the landlord doesn't really have any other tool when it comes to a non-paying tenant other than the big hammer in the end. That's the only way they can remove the tenant. That hammer's out of the landlord's hands for now. But it doesn't mean the landlord will never have the hammer again. I mean, at some point, the peacetime emergency is going to get lifted. And when it does, then the landlord can file the eviction. And what I would be doing if I'm in a landlord's position is frequent updates to the tenant. And by frequent updates, I mean certainly once a month, right? Hey, look, you didn't pay your March rent, or maybe they paid March rent because the COVID pandemic didn't really get declared in Minnesota till mid-March. So let's assume March's rent was paid, but April wasn't. So April's rent wasn't paid, May's rent wasn't paid. I would certainly be sending a email or a text or a letter early in each month saying, hey, this is what your total bill is. It hasn't gone down, it hasn't gone away, this is what you owe. And we expect payment. Many landlords are working with tenants right now to set up payment agreements and frequently waiving late fees as part of these payment agreements if the tenant comes up with some sort of plan to get some percent. I'm not sure what percent landlords are requiring in payment right now. But if the tenant is going to make a substantial dent in the debt that they owe, a landlord in this situation might look at that and say, well, you know what? I'd much rather get half the rent right now than none of the rent. What's the deal you're going to put in place to your tenant? Let's negotiate something if we can. And waiving late fees, by the way, in that situation is one of the ways a landlord can look like they're trying to be reasonable under the circumstances to that tenant. And besides, look, if we use the example of $1,000 for rent, the tenant owes $1,000, so they now owe $2,000. They didn't pay April or May. One of the things that tenant is doing when they're looking at this debt that's increasing is they're thinking, well, all right, maybe I have some of this. Maybe I even have all the rent, but I don't have the late fee. And since I have $2,000, but I don't have $2,160 because that would be the 8% cap that a landlord could get. Let's just use that. So that'd be $80 a month. Since I don't have $2,160, what's the point in me even talking to the landlord if I don't have all of it? Well, trust me, the landlord probably wants to hear from you if you have the $2,000, and they might be willing to waive the late fee if you agree to pay all the rent that's due. But if there's no line of communication from the landlord saying anything like that, there's no reason the tenant would suspect that the landlord would do that. On April 1st of this year, there were several massive landlords throughout the state that actually sent out letters saying, hey, look, we know the world just changed. If you're not able to pay the rent, let us know what you can pay. We'll see if we can work out a payment plan, and we're willing to waive the late fees if you're willing to commit to something right now. And I thought that was a good, bold move by landlords. They didn't have to do this, and so that was the reason that that was the reason why these landlords did this, to try to encourage these tenants to pay what they could, because they thought that collecting a decent chunk of the rent was better than demanding all of it and getting none of it. And so opening up the door to a partial payment plan, if a landlord is struggling to make all their bills, and I know that there are landlords that are struggling to make all their bills right now, that might be the most effective move right now. And it doesn't mean you can't file an eviction later. That's still a possibility. It depends on how you work out the payment plan.
The next question is about late fees, and we actually got another question just in the Q&A box right now, so maybe we can tackle both at the same. So the question submitted in advance sounds like it's maybe from a tenant. What should we do if a landlord or property manager is trying to charge late fees? Is this legal under the current moratorium? And the question just submitted now, are landlords still allowed to charge late fees? You said they waive them, but it is not required to waive them.
Okay, great question, and it is confusing. I don't fault anybody for wondering what the right answer to the late fees question is, maybe even based on what I've just said. So I'll try to break it down a little bit better. Number one, the governor's moratorium does not ban late fees. It does not. It does not say anything about late fees can't be charged. It does say a landlord can't file an eviction. It does say a landlord can't terminate the tenancy. These are really clear, unambiguous phrases. However, it does not say anything about a late fee limit or cap or elimination. There were pieces of legislation in both the House and the Senate at the state level that proposed that, but they didn't pass. So there's no state law that says that. The CARES Act, the federal law that I talked about a little bit earlier, does ban late fees. So if the building is bound under the CARES Act or the tenancy is covered by the CARES Act, then late fees are not allowed, even if they would have been allowed under the contract plus, I guess, state law. Those two combined equals how most landlords are allowed to charge late fees legally currently. But under the CARES Act, late fees are not allowed. So in 20 to 50% of leases in Minnesota, late fees not allowed, but not because of the governor's moratorium, but because of the federal rule. And so a landlord can charge them in 50 to 80% of Minnesota tenancies. As I mentioned, many landlords have decided to waive the late fee, and I think it's largely to try to encourage tenants to get closer to paying the full amount of their base rent. And hey, landlords are people, obviously, and landlords are allowed to say, you know what, you're our customers. We know that you're struggling just like we are right now, but we want to keep good customers, and so we're going to waive this late fee that we don't have to waive, but we're trying to accommodate what we can. And so we will be reasonable about the late fees and knock that fee off, give you this concession while we're all dealing with this difficult time. And so, although the law might not mandate it, it might be a good strategic business move to waive the late fees. And, I'm not going to say it's the moral thing to do, but some landlords, I think, have decided that it is. And that's, up to them, and great if they do, but they're not required to do that unless the CARES Act covers their rental.
All right. Next advanced question. Metro HRA sent us paperwork, us being a landlord, with new guidelines for rental rates. What if we get paperwork like that from a housing authority? I'm assuming this landlord maybe has a tenant then with a Section 8 voucher through Metro HRA. And so what do they get? What do they do if they get paperwork from Metro HRA for an increase in rent for a lease renewal that's in September?
And I think you were going to answer the first part of this question, and then I was going to answer the rent increase part, right?
Yeah. So I think I think the answer is, well, and maybe this is what you're going to give, is that the state's eviction suspension probably does not allow for rent increases right now. There is guidance that I'd suggest, and I looked through it a bit. There's guidance from HUD to public housing authorities, and I'm going to put the link in the chat in a minute here, regarding the CARES Act and regarding sort of frequently asked questions and notices and guidance around what public housing authorities are supposed to be doing related to vouchers and a variety of other things. So I'll put that in the chat. I'm not sure if there's really a lot of clarity from HUD on it, because in many cases it can be dependent. I mean, they can advise around the CARES Act because that's federal, but each state and even some local cities and other areas have different eviction suspension rules and rent increase suspension guidelines. So and you can answer the second part.
Yeah, the second part is so the governor has issued lots of executive orders. Some of them are directly on landlord-tenant law, some of them are not. There's an anti-price gouging rule is one factor to consider here. So rent can't be raised. By the way, housing is considered in the price gouging as a service that counts for, you can't raise the prices too quickly or too much. There's a 20% hard sort of bright line rule that says you can't raise rents more than 20% or any other prices on essential goods. But that's not the only question. It's also if it's an unreasonable difference between what it was prior to COVID-19 versus now, the period 30 days prior to COVID-19. So any rent increase first has to pass the price gouging cap. And just so we're clear, that is a complete deviation from normal landlord-tenant law. In the past, if a landlord wanted to raise the rent from $1,000 to $5,000 a month because the market changed, there's no law that says that they can't. So right now, that's a temporary limit on how much landlords can raise the rent. Although seeing rent increases over 20% hasn't happened much in the past, not at one point, not 1 year. Occasionally we'll see it where a new owner will come in, take possession of a property, and the old owner's been charging the same rent for 15 or 20 years. This is like a duplex or something because they just never bothered to think about raising the rent or didn't think it was worth it, or they really liked their tenants and they wanted to keep them. But if the new owner comes in and does a market analysis and realizes the place is way undervalued, we see massive rent increases sometimes, a big jump making up for the last years. If you want to think about it that way. And that would normally be illegal, but right now it would not be because of the price gouging rule. Likewise, any change in the rent, arguably, and we've actually seen the Attorney General's office start to say that this is probably the right analysis, but any change in the rent is a change or termination of the original contract. This gets a little bit complicated, but basically, if I have a contract with my tenant and the rent's $1,000 a month, and we're there for a year, and the lease ends at the end of May, and I decide to go with my sort of standard rent increase of 5%, so I go up to $1,050. I have effectively terminated the $1,000 a month lease and demanded that the tenant pay more. And we've seen indications from the Attorney General's office that they view that as a termination of the tenancy in violation of the governor's order. So locking in the rent at one rate might be the only thing that we know stands up under executive order analysis. Again, I can't point you to court cases that have determined whether this view of this executive order is the right one or not, because courts are in a lot of ways closed. So it's difficult to know for sure what a court would do, but I think that's the right ruling of the governor's order on raising the rent at this point.
Yeah, and I think I want to add to what I said and what you've said in that, the question was about Metro HRA sending paperwork for a renewal of a lease in September. So I mean, I don't think it's illegal right now or against the order to sign lease renewal paperwork, and maybe not even to sign something that says there may be a rent increase in September. But if the order is still in effect in September, the rent increase can't happen, and maybe the notice right now in the midst of the executive order being in effect is not valid. So I mean, I think your best bet is to talk to the worker, the folks at Metro HRA on it. The next question, and there's another question in the current Q&A box that's similar to it. Is there any available options for owner-occupied duplex landlord who counts on rent to cover mortgage? Tenants lost their job and the landlord doesn't want to evict. And then the related question: any help concerning mortgage payments for landlords?
I'll be honest. We have done everything we can to know what landlord-tenant laws are out there and try to stay as current on those as possible. We do run a tenant hotline, so we have a list of what we know are the available financial resource availability for tenants, but I'm not even sure that that's completely current because there have been new programs that have come up frequently. But I don't know of the programs that might be out there that a landlord could get more mortgage relief on or help covering bills. I'm afraid it's just not something that we've been able to keep up on. I think that there's some of the small business stuff that's generally federally driven that might apply, but I'm not honestly sure. So the short answer is I don't know of any specific place to tell you to even start. Eric, where would you send somebody that's asking that question?
They might want to look into if you are covered under the CARES Act, because there's provisions in there. If you're not, then I guess the suggestion we can provide, and I'm putting our general COVID page link in the chat, because there's some information there. It's for tenants, but some suggestions for tenants if they can't pay rent, what they should do. So you might just try to work with your tenant in terms of see if give them some of this information, some of the resources to apply for unemployment, or if you're in Hennepin County, for example, Hennepin County now has a rental assistance application that is out still, and I'm putting that in the chat. Ramsey County has approved something. I'm not sure if they've started allowing tenants to apply yet. So there, depending on where your location, you might be able to encourage or refer the tenants to resources. Next question: did the Minnesota legislature pass a law limiting fees to tenants for breaking terms of the lease? For example, pets, cleaning, utilities.
Okay. So that question, there's two parts of it, and I'm not sure if they're related or not. But the first part is that I'll answer is: can a tenant break their lease because of COVID-19? There has been no new rule about that. So a tenant saying, I want to get out of my lease because I lost my job because of COVID-19, there's no law that says they get to break their lease for that reason. I'm worried because I'm sick or I have to take care of a sick family member. There's no specific COVID-19 rules that have come out saying a tenant is allowed to unilaterally break their lease in that situation either. I guess a tenant might be able to argue some sort of fair housing claim, Americans with Disabilities Act, that if they contract COVID-19, they should be able to break their lease. They could make the argument, but it's not a sure thing in a federal court. There was actually legislation proposed this year and has been proposed for several years at the state level that tenants be able to vacate their rental unit if they were suffering from some sort of medical condition and they got a note from a medical professional saying they needed to break their lease for that reason, which is the law in a handful of states, but that was not passed. But no, there's no specific law that says that a tenant can break their lease because of COVID-19 related issues. Now, there are arguments, like I said, the Fair Housing, the Americans with Disabilities Act. There's something called a force majeure concept, which is sort of an act of God notion that if the tenant can't perform the lease, there's just no way that it's possible under conditions that have been created, they might be able to get out of a contract. I would not bet much of anything on that argument in court. I'd still probably, if I were a tenant's lawyer and they had nothing else, I'd make the argument, but there's so few cases where force majeure is used as an actual defense to something. I think the place we'd be most likely to see that argument is going to be in the fall when college students who have signed up for really long range leases, this is how these leases are done in college areas right now, is a tenant or a group of tenants will be living in a rental unit. They move in September, let's say, when school starts. And then on October 15th, the landlord comes by and says, I'd like you to re-sign your lease now. What do you mean re-sign our lease? We just lived here a month and a half. Yeah, I know your lease ends in 10 and a half months, but we'd like you to re-sign your lease for the next year right now. So we have a lot of tenants, and this is a college area phenomenon, at least for now. But it is a college area phenomenon. That's the only place we see it. And I'm not exaggerating the dates here. Landlords will ask tenants to sign leases 11 months in advance, 10 and a half months in advance. So many tenants did that. And this fall's rolling around, and now schools aren't even sure that there's going to be schools. And so these tenants are locked into these contracts for another year that they may not be able to go to school at. And so they're wondering, hey, am I bound to this contract that I've signed? And the force majeure clause might be the only thing that they have to rely on to try to get out of the lease. Again, it's not a sure thing, but it's a possible way out. And I'm not sure that tenants would have any other argument to make, so that might be the one that they end up making. The other part was, can a landlord charge, what was it, fees for what?
No, I'm not sure. It was asking if the legislature passed a law about limiting fees. So.
Well, I know that the legislature passed no laws like that, for sure. That's the easy answer to that question.
Next question, can a property manager require residents to wear a mask if the resident requests an in-person meeting?
That's an interesting question. And I say interesting because I'm not sure that I've thought about it much before right now, because we haven't heard that from tenants that landlords are requiring that sort of thing. Looking at the governor's most recent shelter-in-place orders, it looks as though masks are encouraged, strongly encouraged, I might be the word that the governor uses for any kind of public setting, and I guess a meeting with a landlord would probably be that. But I don't think it requires it. I think that if I'm a landlord and I want to stress the safety of everybody involved, I would tell tenants something like, hey, you know what? We need to set up a meeting. I will be wearing a mask. I will be wearing gloves. If you don't have a mask or gloves, I'll be happy to provide them to you. They'll be waiting outside the door for our meeting. And then we'll be happy to meet, but we need you to wear those items. And if not, maybe we can arrange a meeting that's done, by Zoom or Skype or on the phone or whatever might suffice if it would suffice. But if you really want a tenant to follow that rule, I think you make it as easy for them to follow, and you also lead by example by saying, I will be wearing the mask, I will be wearing the gloves, and I expect you to do the same, not just for the safety of you and I, but I have 10 meetings with tenants that day, and I want all 10 tenants, along with me and my staff, to be safe, and this is the best way to try to ensure that.
Next one is pretty general. Maybe you've answered it. How are Minnesota's eviction laws changing now that the governor's order is lifted, which is not true?
Well, again, I don't mind the question, and I don't mind restating, again, the most important, stuff that the reason why we're doing these webinars, honestly, is because we're trying to make sure people understand the rules versus the guesses or the rumors or the gossip that they've heard. The shelter-in-place orders don't relate to the eviction moratorium. They just don't. And I know we've all seen in the media the various dials where the governor's talked about what's going to open, what's not going to open, what's next to open, things like that. Not related to the eviction moratorium at all. That's related to the declaration of the peacetime emergency. So, as I understand it, every Wednesday night, or Wednesday sometime, the governor makes announcements about what is happening with the dials each week, and it can be really confusing. But those dials don't have much of anything to do with the eviction moratorium. That's based on the peacetime emergency declaration.
Right. That's everything we have sent in advance.
Okay.
And okay. Oh, so is there any help available concerning utility payments for landlords, specifically not from tenants, any grants, etc.?
Yeah, again, I don't know. I mean, I might start with a place like the Minnesota Home Ownership Center would be a place that if they don't have an answer or a list of resources, they probably know where to call to get that. But I'm sorry, it's just not our client base, so I don't know what all resources are available to landlords.
And again, I think last week a similar question was asked, and one of the suggestions we gave was check with your city. I guess it depends on what the utility payments are, but for example, in Minneapolis, Minneapolis's water utility website does say that they're not going to shut off water for non-payment, and it has information about contacting them. So check with the provider. The next question: has there been any guidance on what, in quote unquote, endangering others may be? I'm guessing that's in relation to the governor's order that mentions that.
Yeah, no. I don't think there's any additional guidance. I guess as a starting point, if any citizen wants to get a restraining order, an order for protection, kind of the phraseology that lawyers use is that you have to sort of a threshold minimum to get one of those generally is that somebody has either attacked you physically or threatened to attack you physically, sort of directly, right? Not just some offhand, I don't like you remark or something like that, but an actual specific threat of some type of violence. That sort of thing might be a decent threshold starting point. Now, obviously, you'd have proof issues. An eviction is different from an OFP or restraining order kind of request, which is usually done ex parte, where only one side is present. The person in fear gets to ask for a temporary restraining order in general, and then later the person the restraining order is against can contest it, but it is immediately granted if at least the allegation is sufficient. In an eviction, the tenant has a right to show up and say, I don't think I'm endangering anybody else. Prove what you claim that you say I said, right? And then it's up to the landlord to be able to show that and that it's legitimate enough that the tenant should be evicted for that reason. Honestly, I think the lease probably has to have some language discussing endangering others as well. I don't know that the governor's order gives a landlord suddenly newfound powers to file an eviction. The guns, drugs, prostitution, stolen property, that's part of every lease, whether it says so or not. That's been in the law since the early 90s, and it's included there, again, whether the lease says so or not. But the seriously endangering other tenants, again, that's something that might need to actually have some sort of similar language in the contract itself. But there's no clarification of what seriously endangering others means from the governor's order that I've seen for many cases so far.
I mean, maybe a parallel is that is the expedited procedure statute that uses the phrase other illegal behavior that seriously endangers the safety of other residents.
Sure, which would be another place that it could come up. But the restraining order is certainly the more common of those. There aren't many evictions filed for the drugs or seriously endangering things.
The next question is kind of I think a restatement, clarification of a previous question. Katie says, I want to clarify the question that I asked. We gave the notice settlement agreement at the end of January prior to the moratorium to vacate April 30th. Are you saying that is not a valid notice because it ends during the moratorium and we have to provide them another notice or sign another agreement?
Yeah, Katie, I think that the notice that you gave that ends at the end of April, so the tenant is still there on May 1st, is unquestionably waived if you accepted May's rent, or even probably if you asked for May's rent. If a landlord, this is pre-COVID-19, if a landlord gives a notice to vacate for a certain day, let's use February 29th this year, and the tenant didn't go, but then on March 1, the tenant paid rent and the landlord accepted it, that notice to vacate for the end of February is waived. It makes sense if you think about it. You shouldn't have accepted rent for a future month if you're telling them to leave by the end of the last month. And so if there was rent paid on May 1, then unquestionably, in my mind, from a legal standpoint, that notice to vacate has no legal effect. Again, my cautious advice would be here is that since that notice is probably dead, it's waived, then I would wait until the eviction moratorium is done and give a new notice. I'm not sure why you gave a notice at the end of January to vacate the end of April. That is a 3-month notice to vacate. It's a pretty rare lease that requires a 3-month notice to vacate. Most require 1 or 2 months of notice as sufficient to end a lease or non-renew a lease. But anyhow, my cautious advice would be to give a new notice at the end, because that notice to vacate is probably invalid at this point. Almost certainly is.
All right. The next question I think might be another clarification of one submitted in advance. How do we best find out about recent laws going into effect soon if they have passed? They've been trying to remove the ability to charge fees. And then there's a link to House File 3348, which is actually a bill that that Homeline has advocated for. This bill did not pass this session. I think it had a hearing in the House, in one House committee, and it did not. It passed out of committee and did not have a hearing in the next committee, so it's not a law. So I think that answers that question. But
Yeah, I mean, look, if you want to stay informed, honestly, that's why we're doing these presentations, and we aren't trying to hide any rules from landlords. It's, again, we are a nonprofit designed and created to work on behalf of renters. And one of the things, there's a reason why our office has done landlord speeches for as long as I've been around, since 1996. And I know I've talked to over 200 groups of landlords over my career, is because we feel that informed landlords are ones that are more likely to follow the rules, honestly. And so that's why we try to make sure that landlords get the right answer to what the rules are, because look, this is a regulated industry, and right now the regulations are changing fast and furious. And I don't fault Tony for asking, how do we know if it's a law? Eric, you're right, that law isn't a law. It was a proposal. It never went into effect, and so it's just kind of a theoretical thing now. And at present, the House and the Senate are not in session, so they can't create any new laws at all.
And just a clarification on that too, and maybe you mentioned already, but the executive orders, the peacetime emergency requires, effectively requires that the legislature reconvene on its or before its conclusion. So if it's extended, and this gets to the next question, what happens if the peacetime emergency gets extended again? So right now it's set until June 12th, Friday, June 12th. Is it fair to have landlords paying to keep houses maintained and expenses? And shouldn't there be a limit on how many months this can go on? Not all landlords are big corporations, but are private individuals. Tenants knowing we can't evict, so not paying affects our bills. I guess I don't see why eviction and peacetime are tied together and not separate policies.
Yep, it's a fair criticism. And honestly, if a landlord doesn't like what the governor is doing at this point, there are, I think, 2 avenues to trying to solve it. One is to contact the governor directly. I would guess that everybody watching is a Minnesota resident, and so the governor is your governor as much as they are the tenant's governor. And so you have a right to contact the governor and say, hey, this is having a huge impact, and I don't want this to continue. The other way to get the peacetime emergency stopped, which would have the effect of stopping the eviction moratorium as well, is to contact your legislator. Again, the Senate and the House both have to vote on this, but if both houses vote, both chambers vote to end the peacetime emergency, it doesn't matter what the governor wants to do going on here. Is the governor making the right decision on everything? I don't have any idea. That's way above my pay grade. I don't envy, honestly, any governor in the United States right now trying to make these life and death decisions, which is what they are, about how to try to maintain businesses while, making safety a priority. Tough spot. Anybody that thinks these are easy decisions just isn't thinking it through. Tough decisions. Now, you might not agree with them, these decisions, but they are hard decisions that our elected officials are having to make, probably the hardest decisions they'll make in their entire careers. But unless they hear from the affected people, so if landlords don't bother to call the governor or contact the governor won't know exactly what's going on. I should mention that Minnesota Multi-Housing, which is, again, this landlord rights trade group, sent out a policy memorandum days before the governor banned evictions, saying that there should be no evictions filed until at least May 31. This was the biggest voice for landlords that I know of in Minnesota is the Minnesota Multi-Housing Association. And they said there should be no evictions filed until at least May 31 and no late fees as well. So the multi-housing actually wanted to go further than the governor did originally. And so I get it. I get it that there are landlords that don't have a lot of rental properties and they're counting on this income coming in. And so is it fair? Wow, that's a hard thing to try to answer the question on. I can just tell you what the rules are right now more than anything authoritatively.
And I'm going to put in the chat the link to Multi-Housing's announcement that was early or mid-March, I think. Mm-hmm. The other thing to add is that the legislature has been, or we're debating resources, rental assistance resources through FHPAP, a state and county program that would have significantly increased the resources for tenants to pay who are unable to pay, and there were disagreements over that, and it didn't pass. The Senate wanted only 30 million, which seems like a pretty low estimate, and the House wanted 100 million, which honestly I think is a low estimate now too, given that we're heading into June. But there was disagreements over it.
And if I understood those proposals, the money was to go directly to landlords, right? It was not going to be to the tenant.
I believe so.
Yep. Yeah, I think that's how those are drafted. Yeah.
And I think also there's been a number of other programs that have popped up that are providing assistance on a local level. Cities like Minneapolis and St. Paul with their funds, and then the counties are distributing through additional CARES Act CDBG funding rental assistance. So there's some resources out there. There's not enough, and there should be more. Katie mentioned.
Yeah, I see the three-month notice period. Okay, yeah, that's uncommon, but I've seen it. Sure.
And then Kimberly has a question: can they vote? They being the legislature, I assume. Can they vote to separate the eviction moratorium from the peacetime emergency, allowing them to have other items continue, but end the moratorium?
I don't know. I've looked at the peacetime emergency statute quite a few times and read it through. It's not exactly something you can look at and say, oh, let's see how it's been dealt with in the past. What are all the precedents? Because there aren't any that really matter for what we're dealing with right now. And so it's hard to know if the legislature would be able to end the eviction ban while maintaining the peacetime emergency. I think it'd be tricky to do. I'm guessing it'll all happen at once it does happen, if the legislature decides to go that route. I noticed one question in the chat box, by the way, from Tony, that I wanted to just address quickly too, Eric. The CARES Act.
Yep. Yeah, I missed that. Is the CARES Act over assistance tenancies? I'll have to ask this of our brokerage.
So I'm not exactly sure what Tony's asking there, but I think he's trying to figure out, how does he know if the CARES Act applies to his property? Is that what you're thinking he's asking? And if so, yeah. I think, Tony, your instinct is right. You probably need to ask whoever you got your mortgage through. which is why, by the way, it looks like in Hennepin County, they're going to be requiring landlords to disclose that they are not covered by the CARES Act, or that they are covered by the CARES Act if and when they file an eviction once the eviction doors open up again. That's been the case in several other states where it's up to the landlord to disclose whether the CARES Act applies to them or not and sign the eviction papers under oath of perjury, just like always. The landlord is probably the only party in the world that can really gain access to this information quickly enough to make it meaningful. I suppose a tenant, if there was litigation ongoing, could subpoena and through discovery obtain the mortgage and be able to contact the mortgage provider, but the actual owner of the property who has the mortgage can find this out from their mortgage originator, who has no duty of confidentiality problems by telling the person who got the mortgage from them exactly what the situation is as far as, is this a federally backed mortgage? So starting with whoever gave you the mortgage is going to be the key first step for a landlord in deciding whether or not the CARES Act applies to them.
And in the chat, I put the thing that, so the ProPublica, we've been sending out a couple things. NLHC has a database, but this thing that ProPublica put together is you can actually put an address in and it'll tell you if it's tied to the CARES Act. Again, those are all the larger buildings. It does not include units that are 1 through 4, or buildings that have 1 through 4 units that are federally whose mortgages are federally backed in some way. Not seeing any more questions. It'd actually be helpful if we wrap up early here because we have another webinar to start. So just a reminder that we are doing these weekly. Let's see if I can put it up there. I guess I can't. Weekly on Thursday afternoons at 1:30, and the recordings of all of these are on our website. I sent the link earlier, the COVID page, send it again. And so we will send you all the folks that attended today a follow-up email with a link to the recording for today and the registration for next week, and a link to all those previous recordings. With that, we will call it a day. Thanks everybody.
Thank you.